afternoon, everybody, and welcome to our special election calendar for May 10th. We have 3 cases on the calendar today. So the first one is King versus Simpson. The attorneys want to rise. So who is the appellant for Ms. Simpson? Okay, and how many minutes did you want?
7 and 3, please.
Okay, and who is here for Respondent King? And what about, we have the intervener city here? Okay, so I'm gonna give, I'll give you 6 and 3, I'll give you 6, and I'll give you 6. And if we have additional questions, we'll go on. So please be seated. Let me just call out the next cases. Tuck versus Board of Education. I know there's 2 applications, but they're similar, so assume you can handle those together. So who represents the petitioners? The appellants? That would be Mr. Schwartz. He's not here. Is that why you're looking around? Well, let's assume that he'll be here, and you represent the Board of Elections, correct? And you asked for 3 minutes, and you represent the respondent, objectors, whatever. You're Mr. Newell. Yes. And how many minutes did you want? 7. Well, I'm going to give you 5, so I'll give him 5, you 3, and 5. So it'll be 5 and 3 and 5. Okay. If we have questions, we can run it an extra few minutes. So please have a seat. Let's start first with the King versus Simpson case. Appellant. Thank you. Okay. We just refigured the courtroom, so everybody's back here after 3.5 years. So it's like, ooh, wow, you're so close. Okay, good afternoon. You may begin.
Good afternoon, Your Honors. William Ferrero for the appellant, Allison Simpson. The trial court erred when it determined that expulsion wasn't encompassed when the word remove was used. And really, the words remove and expel are quite synonymous. If you look at the Merriam-Webster definitions of both words, to take away is used in the definition of both. And the petitioner wants to use this tortured analysis comparing the word removed across dozens of other instances.
Well, does it matter that there is a separate section of the New York City Charter, I believe it's section 45, that talks about expulsion, and that's different from the section that talks about removal?
So 45 uses the word expel, and then 25 uses remove. And when it's used in 25, that's used to explain a situation where you have your membership taken away. And expel also means the same thing, to take away.
So it's an involuntary action, in other words.
Correct, yes. The word resigned was used to explain situations where voluntarily you remove your membership from the city council.
That's in the section 1100, I forget, 35 or something.
1138, yeah, when it talks about term limits.
That's talking about the term limits. That's
right.
Just, that's how they figure out how you would prevent, as the city was arguing in their briefs, how there would be a situation if someone resigns before their term ends, they can get another term or run for another term.
Right, right. And so 1138 was enacted by a voter referendum where they decided we only want our politicians to have 2 terms in office, no more than that. However, they didn't...
Two totaling 8 years.
2 consecutive terms totaling 8 years.
Right.
Right. So what they didn't consider was that in these redistricting years, which 2002 was, there was going to be a situation where a 2-year term was going to count as a second consecutive term, and that was going to disqualify them from running again for the second 2-year term.
And that's where the city charter corrected that sort of
Right.
anomaly.
So then they went in to amend it, and they said, okay, these 2-year terms will be determined to be 1 full-year term. But then they also considered what would happen if someone were to leave the second term early. And they use the words leave the term early. And in order to cover all situations where someone were to leave the second term early, they use the word resign. You voluntarily remove yourself from your membership as a city council, and then they use the word remove to explain what would happen if you're involuntarily taken away your membership, right? And that, again, that goes back to expel, remove. They both use the words take away in the Merriam-Webster
Is there a
dictionary.
process under the charter to remove that wouldn't include expulsion?
So not for city council members. There's other offices where you can be removed by a different,
Superior office.
a superior office or an alternative office.
So the net effect of this would be, is essentially we're excising the word out of the statute then, right? If we agree with Supreme Court, because remove then has no meaning?
Right, so if you agree with the Supreme Court, then that would effectively render the word remove in 25 to be meaningless.
Somebody was expelled, that they would no longer be subject to term limit, that they would not be
Correct,
subject
correct.
to term limit.
And I believe that would undermine the voters' decision when they voted in 1993 to say, we only want 2 consecutive terms, a total of 8 years in a row.
Sort of allow people to kind of end run.
Right, it would circumvent the term limits, which I think pretty clearly the voters.
Yeah, because if 1135 prevents, like, when you resign, you can't, use that, or you can't resign in your second term so that you can get another term.
Right,
Because if we were to agree with Supreme Court, that would just literally undermine 1135's purpose.
Right, and they specifically contemplated a situation where someone were to resign, a few days before the completion of their second term and then try to run for a third term. What they didn't contemplate was that we would have these events all occur at the same time, where the petitioner was expelled, and then it's a redistricting year, and they didn't contemplate all these events happening at the same time as it did this year. But I think certainly they wanted to cover involuntary leaving or voluntary leaving in that second term, and to make it so that the voters' decision was respected in that only 2 consecutive terms would be allowable for a city council member. And I think if there's no other questions, I don't need the rest of my time. Thank you very much.
Okay, thank you very much. Do you have a preference of who goes next? Well, you're the,
I'm responding to all the appellants are done, then I guess I'm done with my judge's life.
well, that's the intervener, so you would go, I would think you would go last. So I'm going to have you go next, okay?
Okay.
Thank you, Counselor.
Thank you. May it please the court, my name is Ali Najmi. I represent petitioner respondent Andy King. Your Honors, this court should affirm the lower court's decision. Justice Billings got it right. Mr. King was expelled on October 5th, 2020, in the middle of his second term. He still,
Isn't the implication of that somebody who's expelled, removed from, or as as many people would say, removed from office, would not be subject to the term limits that were adopted?
well, Charter Section 25 only articulates 2 instances in which a council member's vacancy arising in the middle of a term would be deemed to be a completion of the full term, and that's resignation and removal. Removal does not mean any type of vacancy. There are many paths to
What is a removal? What's a removal? Isn't a removal and expulsion the same things? It's essentially an involuntary act, and the person is removed from office.
Removal is the removing of a subordinate officer or elected official by a superior elected official, and there's overwhelming authority for them to be distinguishable.
But we just heard from your adversary that there's no process. So in other words, if we were to accept the argument you're making and Supreme Court's making, removal means nothing in Section 25.
Article 13, Section 5 of the New York State Constitution, which permits removal statutes to be drafted, specifically says it must exclude local legislators. Removal cannot apply to local legislators pursuant to the state constitution. And There are many different paths to a vacancy. That statute, removal doesn't mean any type of vacancy. If that's what that statute meant in Charter Section 25, they should have said that.
But why shouldn't we apply the ordinary meaning of removal, which is to involuntarily leave? And involuntarily leave can include both a removal pursuant to the statute you're talking about where someone's removed by a higher official, and it could also include removal by your peers, which is what happened here.
Well, I would respectfully state that there is a legal meaning of removal. We see that legal meaning throughout our state law, in the Constitution, in the Charter, in multiple sections of the Charter. We see it in case law.
Is there anything that says that removal cannot include expulsion?
Article 13, yes, the New York State Constitution, Article 13, Section 5, specifically states that removal cannot apply to local legislators.
But it doesn't say removal and cannot include the term expulsion.
That's right. It does, but it says it cannot include, removal doesn't apply to local legislators. Expulsion is a
But
peer sanction.
in that context, removal means removal by a higher body.
Expulsion is by definition a peer sanction. It's not a removal or a firing by a superior officer. A local legislator cannot be removed. They cannot be fired. They can be expelled by a peer sanction, and that peer sanction has to have a check on it because there's an anti-democratic problem that comes with an expulsion that can only be checked by a new election.
Why would someone who is removed by peers, and then someone who's removed by a superior officer, and as opposed to someone who's expelled by peers, why would someone expelled by peers? Let me say it differently. What's the difference in terms of the involuntary nature of that vacancy? They really accomplish the same thing. So why would someone removed, in your view, be subject to term limits, whereas someone expelled for a variety of reasons, why does that person get a pass in terms of the goal when you look at the whole change in the law and the whole term limits, as my colleague pointed out, in terms of why 1138 was enacted? I mean, why does, let's do it this way, why does Mr. King get a pass here versus someone that Mayor Adams would remove?
Well, I wouldn't say it's a pass, Your Honor. First, it goes to the heart of what an expulsion is. Because it's a peer sanction, you're being removed, you're being excluded from the council by people who are not representing your district. A superior officer represents, potentially like the governor, would still represent people from King's district or the district of the officer that they're removing. In expulsion, in order to check the anti-democratic principle, that check is a new election. There was nothing stopping Mr. King from running in the special.
Is there anything in the legislative history that supports that removal does not include expulsion by one's peers?
There's absolutely nothing in the history of Local Law 27 that says expulsion was contemplated by that amendment. And there are many paths.
Counsel, I got to ask you a quick question. The Section 25 we're talking about talks about in terms of determining whether or not you finished your term. And there are two situations in Section 25. One is resign. You're considered finishing your term, right? Even if you leave before your term is up. And one is removal, right?
Yes.
When you're arguing that we're talking about superior officers or superior getting rid of someone junior or subordinate, that's a removal. But Section 25, I'm not so sure. The way it's phrased, it talks about terms. Only people that have terms are the mayors and the city council members, right? No one else, no officers or employees or subordinates of the mayors have terms. They're at will employees, right? So that when you're talking about removal here, it's in the context of a city council member or maybe any other elected official like city controller or the mayor or the public advocate, because those have terms.
It applies to all these elected officials who have terms, but
Okay,
I would
here's the next question that I have. You're arguing that the state constitution says you can't remove local legislator, right?
Correct.
So is your next argument then that the term remove in Section 25 can't be even viewed at all, that's contrary to the state constitution because it's there? Is that
Correct.
what you're arguing?
Correct. A removal does not apply to a local legislator pursuant to the state constitution.
So you're saying that that's not constitutional then by even having the word in there.
It's not. It cannot even be read It cannot be read that way. I think that the statute never intended to include
So
expulsion.
how do we read it then? Because we do have to give all words in a statute their meaning. So what is removal, what do you say removal means?
Well, Your Honor, when we look through all the different state laws that exist, there's many different paths to a vacancy. Not all of them are contemplated by Charter Section
No, but
25, for example.
No, but Section 25 is limited to terms, right? So that you have to look at anything else throughout the entire state where there's a term of office in play. And there is no other term of office in play in the city of New York except for the citywide elected officials and city council members. So that when you talk about removal by a superior officer to a subordinate, that doesn't apply here. That doesn't, just by the plain meaning of the statute, it doesn't work, right?
Respectfully, the plain meaning of removal does not include expulsion, and expulsion was not contemplated. There's no authority that says expulsion means removal. And I
get that.
I would just add finally, there are many different paths to vacancy that are not contemplated by Charter Section
You
25.
still haven't answered my question. What is removal? What does removal mean in Section 25?
Potentially-
How do you want me to interpret it?
Potentially, Your Honor, a judge could find an elected official incompetent pursuant to Public Officers Law 31F. It could find that they failed to meet the residency requirement by moving to New Jersey and declare them forfeiting the office. I think these are judicial remedies that could exist under that word, but it certainly does not mean expulsion.
But all those things you're referring to are involuntary actions, right? Because you're removing because you moved to New Jersey.
And on top of that, you're arguing the state constitution, you can't do it. Based on your argument that the state constitution says you cannot remove local officials, you're arguing right now that someone could be removed for incompetency, can be moved outside of the residence of where their district is. By your own argument, you can't, removal has to be excised totally, that we have to not even look at that.
Well, I would say first, removal, absolutely, my argument is that it does not, you cannot remove a local legislator. Your Honor asked me, what could potentially that removal mean? It does not restrict a court of competent jurisdiction.
No, it's either one way or the other. It's either in or out. You can't say you can't have removal based on a state constitution and then answer my colleague's question and say, well, there are instances of removal that are okay.
Well,
it's one or the other. It's either you can remove or you can't remove.
I would agree with Justice Billings' decision that says that they simply parroted the other sections of the charter that apply removal to the mayor, the borough president, the public advocate. They should have included expulsion if that's what they wanted.
Okay, thank you very much. City? Good afternoon.
May it please the court, Alina Jerker on behalf of the city intervener, and thank you very much for allowing me to appear and present argument. We agree entirely with the position that this is a really gross misreading of the statute, and I wanted to just come in and highlight a couple of ways in which this really undoes the state constitution, the charter, home rule, a lot of things that the decision below is just wrong at every turn. And
Can you address counsel's argument that remove does not include expulsion?
yes, that's exactly what I wanted. So first of all, just on the plain meaning, of course, as we say in our brief, it does in many other contexts, and the federal equivalent for legislatures for other contexts. In fact, in their own brief, in a footnote 8 on page 20, they point to a provision of the New York City Charter that provides for the removal of community board members, which is done, it says removal, the text is that you can remove a community board member basically by a vote of the community board for cause, so, or through a superior officer so there's already a place in the very charter that uses removal for pure expulsion.
But by his own arguments, I don't know if you heard, the way it looks like it's either one or the other. You can't have both, because then he was giving us examples of removal, which he thought was arguing was proper under Section 25. Well, that's a distinction without a difference, whether you're non-resident, whether you have mental incapacity, or you're expelled by your own peers. What's the difference, right?
Agreed. I mean, there's two, maybe three things that come into this. The Public Officer Law 30, which he's referring to, is those removals by operation of law, things like that includes death, includes resignation, it includes removal, it includes court orders finding someone incompetent, includes, moving out of state, no longer meeting qualifications. It's not a removal based on for cause in the same way. It's really neither here nor there, though. The point is that Section 25 has a point, and the point of it is that when the council members remove, they have term limits. What they're suggesting is that that would be unconstitutional under the Constitution. I
He
want
wants
to
us to
point.
ignore the word removal. The removal,
Exactly.
even though it says removal, it's not constitutional to have it there.
So let me highlight 2 reasons that's wrong. First of all, the very provision they're talking about, it's Article 13, Section 5. It's not a prohibition. It doesn't say that you cannot remove. It says provision shall be made by law for the removal for misconduct, blah, 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 for people whose duties are not local or legislative. So there's 2 things there. First of all, if their argument were correct, there would be no removal of any local officer at all, not just council members, not the mayor, not anything. The entire charter, every mention of removal would be unconstitutional. It's not, because this isn't a prohibition. This is an authorization, or really a direction to create law for the removal of other types of officers. It's a complement to then the Article 9, which is the municipal home rule provision, which then provides, so the state is providing for the removal
Whatever the state doesn't say.
and the state has no say in the removal of our officers. Instead, Article 9, Section 2 of the municipal home rule provision provides that the local government shall have the power, blah, 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 subsection 1, to determine the powers, duties, qualifications, number, mode of selection, and removal of local officers, including from the members of the legislative body of the county.
Well, that goes back to my colleague's
No question.
my colleague's point about the word removal. I mean, there's just so many variations of what removal interprets that you could fill a whole book in terms of what constitutes a removal. And the way it looks like, if you read the statute, remove is very general. Like, remove means revoke, involuntary. That's the definition.
Yeah, that's what we would
remove.
submit the city council's purpose would have been in adding that provision, which is to ensure that you don't have an end run around the term limit provision. The idea that if we would...
Be it by
if city-
resignation or removal.
Yeah, and if city council expels a member, you reset the term limit clock and they get 8 more years, whereas if this person moves out of state and is removed by operation of law, that doesn't make any sense. The whole purpose is to give effect to the voters' decision that city council members, the comptroller, a couple of other officers can only serve about 8 years, plus or minus, depending on special elections. That's not the idea that this would, the expulsion of Mr. King would allow him to serve, I think, something like 16 plus a couple special elections, is just unprecedented, and it would really just undermine the purposes of the charter and all of the local provisions at play. If you have no questions, thank you so much for hearing our argument.
Thank you.
I may make a
Sure, you have a
quick
few
points
minutes.
here. The statute should be read to give effect to the intention of the city council when they passed local law 27, which eventually became Charter Section 25. And specifically, they contemplate, again, leaving prior to the end of the term. They were using the ordinary, plain language meaning of the word remove. They say the disqualification for continued consecutive service arguably does not apply in the event that an elected official leaves office prior to the end of that elected official's term. So they're clearly using the word remove in its plain language meaning to have your membership taken away. And that's what happened to petitioner here, and thus he should be disqualified from running for and being elected to a term in year 2023.
Thank you. Thank you all very much. On the Tuck versus Board of Education cases, Justice Oing is recused from this case, and Justice Scarpulo will sit in on these cases. So counsel for Tuck, please come up. Okay, good afternoon. Mr. Schwartz, in your absence, we gave you 5 minutes. We assumed you would be here, and you are. So you have 5 minutes.
I'll try to use my 5 minutes well.
Good afternoon.
Thank you. Your Honor, there were two, I wanted to say the underlying case here involves somebody who submitted 1,500 good signatures. That's on the record. The clerk did a report and analyzed the number of signatures to get on the ballot as to run for district leader in the 74th Assembly District. The initial error that was trying to be addressed was that the board said instead of putting F and M next to their names, they put female and male in the description of the position.
A position with that title no longer exists, correct?
The position with that title no longer exists, but
So the petitions were based on running for an office that doesn't exist.
the petitions were based on a misidentification. If they put female next to their name and male next to their name, it was in a different column. And I think
Right, but the description, the title of the position they were running for doesn't exist as a matter of law at the time of that they filed them, right?
well, what the position is now, the two district leader candidates who of different sexes who get the
Does that
most.
position exist or not? Is there a position called male district leader?
No.
Okay, thank you.
But there, I believe my argument would have been, if we hadn't passed the verification issue, was that there was that they substantially complied with the election law. The fact that they put female district leader and male district leader, the 1,500 people signed their petitions, which I think is the most important thing. They weren't trying to deceive. There was no effort at fraud. They simply misdescribed the position by putting female and male. On the cover sheet that was filed for them by me, it had the right designation. In fact, when they were listed on the Board of Elections docket, one was listed as they were both listed as district leader F and district leader M, which is what we put on the cover sheet, which is in the record. And I think that basically that. Yes, the position didn't exist, but I think that the error does not mislead anybody who was signing their petitions, was not an effort to defraud anyone. And under case law that says that those kind of errors can be, if there's no intent to deceive or defraud, that the Board of Elections is supposed to see that as substantial compliance with the statute.
Do you want to address the service of the notices to appeal on the Board of Elections?
Yes, so the Board of Elections didn't appear at all in the lower court. They never filed a notice of appearance. There was no, so when it was time to serve the notice of appeal, I actually texted Stephen Kitzinger, who often appears on board matters from corporate counsel, and said, who should I serve my notice of appeal on? And he said, I have nothing to do with this. So then I emailed them to the general counsel of the Board of Elections. I emailed the general counsel everything that was filed, and then her response to me was, send these things to Steve Kitzinger. But as I said, the board did not file a notice of, whether they consent or not, they never filed a notice of appearance in the lower court, not at all, not in either time.
In other words, you don't have to serve them with a notice of appeal?
Well, as I said, Your Honor, I emailed it to.
No. I heard what you said, but there's a statute involved, and you serve electronically, and Board of Elections. It's clear under the regs that they haven't consented to that. So how do we deal with that?
Well, as I said, I served the notice of appeal by email on the general counsel of the Board of Elections, and not having any other attorney to address it to, because I had texted Mr. Kitzinger and he said I had nothing to do with this.
So given someone with your, someone with your experience, why didn't you do it the old-fashioned way?
Which
And deliver it or something under the statute?
hand deliver the notice of appeal, given the
Oh, that you filed a notice of
exigencies
appeal
of-
one day before? Did you file your notice of appeal one day?
I filed a notice of appeal on a Friday, and my brief was uploaded on Sunday night.
Oh, so I'm saying, so if you weren't clear about who to serve it electronically and we have the statute in place, why didn't you hand deliver it?
Because I emailed it, and I thought that would be sufficient. That I can
But
only.
email is an electronic service, correct?
I wasn't sure who to serve it on since nobody appeared. Who would I serve it? Go to the board itself and clock it in at the time clock?
Why not? Isn't that what the statute requires?
Because it was, what we were dealing with in terms of time was they closed at 5 o'clock. We filed a notice of appeal at 6:30-ish.
Well,
with all of the,
decisions below were dated May 1 and May 3. You didn't do anything to file a notice of appeal on either of those dates, right?
on which days?
May 1 and May 3, the dates of Judge Billings' orders.
Well, so the initial order, my first reaction was, let's try it again. Let's do a proper verification that the judge will be happy with, have the clients do it. We refiled it on May 2nd. We refiled the second Tuck case on May 2nd. The judge gave us, she signed the order to show cause at around 1:30 p.m. and said, serve it by midnight, even though the statute of limitations had another 24 hours to run. I asked for another 24 hours. The court said no. So we did our best to serve, and then the next morning, the petition, there was argument, and the petition was denied again for failure to properly serve. So we really I didn't want to appeal from number one. I thought it would be easier to just refile it and do it again, not knowing that the court was going to give us 10 hours to effect. We did effect posting on the doors, emailing it, mailing it, and contrary to
I'm
what.
talking about the notice of appeal from the May 3rd decision. You didn't do anything to file that notice of appeal till 2 days later, right?
I didn't do anything until file the notice of appeal until 2 days later. That's correct.
Okay, let's hear from the respondents, and I'll give you.
Can I just say one other thing? Mr. Newell says it's impossible to mail except at the Farley Post Office. The Church Street Post Office, a half a block from my office, is open till midnight, and it was mailed at 11:30.
Okay, thank you. I have no preference. Do you have a preference? Okay.
May it please the court, Paul Newell on behalf of respondents Olivaria, Jenkins, and Napoleon. So just as a threshold matter, I'm not even sure if this matter was perfected. On my way over here, I got notice that the subpoena of records was filed at 11:15 this morning. Also regarding the notice of appeal, there was a notice of appeal filed at 5 p.m. on Friday the 5th, and then an amended notice of appeal.
Did you consent to electronic service? Did your clients, I should say, consent?
Yes.
Yours did?
Yes. Yes, Your Honor. But I just want to note that the amended notice of that there was an amended notice of appeal filed on Sunday the 7th. So further on the time.
Did the Board of Elections consent to electronic filing?
I will allow respondent board to reply to that matter in their service. Again, the court below properly dismissed this for these matters. First, the first matter for failure to properly verify. Counsel was duly notified. Despite counsel's brief claiming that the issue was waived, counsel was notified by email within 15 minutes of the purported service in the first matter, and it was raised in the answer for 13 paragraphs and at oral argument at which the Board of Elections did appear, notified with specificity. The service in that first matter was not calculated to provide notice to respondents before the end of the statutory limitations. The statute of limitations on April 24th, it was delivered to an attorney who had not yet consented or been retained for the matter at 10:03 p.m. on the last night of the statute of limitations. And the service on the second matter is just on its face poor. It needed to be dismissed. The only proof of service submitted at all in that matter was an affirmation from Mr. Schwartz about the actions of another person. I don't have her name in front of me.
Ms. Harris?
Ms. Harris, yes. The affirmation itself acknowledges that it's faulty, saying a more proper one. But even if it were to be given credence, on its face, that affirmation says that Ms. Harris left the papers by the mailbox in the lobby of the respondent's building.
So it wasn't a proper nail and mail on a door?
It was not a proper nail and mail on a door. Mr. Schwartz may refute my argument about the postal service. I can't speak to the church post office is ours. But I can report that none of the respondents in this matter have received any mailing of a 200-page mailing. One of them is signed up for the notifications you get from the post office.
The verification issue, please.
Yes, the matter was not verified properly. It was verified on petitioner's own knowledge with no by Mr. Schwartz, which obviously he is not qualified to attest to. There was no explanation of why he was attesting to, but they were both petitioners were in the same county as Mr. Schwartz. There's no explanation as to why he was qualified to attest to someone else's own knowledge. He was duly notified, duly and properly notified, both in the answer and by email, which was loaded on NICEF, an email to which he replied, I believe. And it was raised at oral argument, and he was present the next day. So, and the documents were returned to him within 24 hours. So he had proper notice. Verification, my clients were entitled to a verified petition under the statute. There are times when that can be overlooked, usually for failure to notify. There's no failure to notify. The notification was specific, and the court properly dismissed it.
What about the issue of prejudice? I mean, was there prejudice?
Well, the prejudice is, first of all, Your Honor, I would maintain that lack of prejudice alone is not enough. You need both failure to notify and lack of prejudice. But the prejudice is my clients are entitled under the statute to a verified petition. We were unable to know if we could rely on the attestations in that petition when replying. It's all the reasons why the statute intentionally, the statute and a case law from Wilson v. Bowman and numerous others say that a special proceeding that is required to be commenced upon a verified petition requires a verified petition, and this was a nullity, and we were within our rights to return it and treat it as such.
Okay, thank you, Mr. Newell.
Thank you, Your Honors.
Thank you, Your Honors. Alina Jerker on behalf of the Board of Elections. I just want to address right away the question that you just asked about prejudice, Your Honor. The problem is that at every turn, there's been a complete disregard of all of the procedural and statutory requirements for notice, for providing service, for perfecting an appeal, for filing an appeal, this court's orders, the lower court's orders. What it really comes together to say is that some people believe there's a set of rules, and the courts have very clearly said, in these highly time-charged proceedings, we need everybody to follow the law. We need everybody to provide all the notice, full applications, full papers, serve, so everyone knows what we're talking about in these really quick proceedings.
So, counsel, let me ask you, you did not consent to electronic filing of
The Board of Elections did not consent, and I know that my adversary has suggested that the board didn't appear. What happened, I think, is that there was a last-minute notification, again, because notice wasn't being provided in the same manner and other litigants had been providing it. As I understand it, Mr. Kitzinger, our trial attorney, ran to the proceedings, did not have an opportunity to appear, and did, though, present argument and explain.
What is the consequence of not consenting to electronic filing of
The old-fashioned way in which people come and they serve their notice of appeal.
and what if they don't do that? So what do you think the remedy is if you fail to?
I think the court fundamentally doesn't have jurisdiction over the respondents in the lower court proceedings or over this.
Which respondents? Over both or just one?
With respect to the board, there's no proper notice of appeal.
Okay, so that-
let's say the court were inclined to go through deeper and reach the
I
merit.
think just answer the question that was asked. With respect to the other respondents, what's the effect? What effect would it have if we were to find that no notice of appeal were filed with respect to the Board of Elections?
Well, your order that would need to direct the board to act, I don't understand entirely.
Okay, so
how it
here's
would have effect.
here's the issue. If the service wasn't appropriate on you, right, because you didn't consent, but counsel for the objector respondents say they did consent, and we said, okay, we agree with you, you have to consent, what would the result of that be? The appeal dismissed as to you, but not to the objectors?
Which then begs the question, what the court's remedy that would be in the petitioner's favor, what effect it would have. Yes.
So if we found that the failure to serve you the old-fashioned way, so to speak, resulted in our not having jurisdiction over you, does that mean that we don't have a necessary party in front of us?
Does, under the election law, the board is a necessary party. I'm sorry
So
that I don't.
if we find there's no jurisdiction as to you, does that mean we have to dismiss the whole case?
I believe that would be right. I mean, as.
Well, the
yeah.
special proceeding, as I understand it, is they are seeking to challenge the Board of Elections ruling
That's
that
right.
disqualified his clients, correct?
That's right.
It's like the Article 78. They're challenging
Our determination, that's
the
exactly.
Board of
right.
Elections.
That's exactly right.
They're, for want of a better phrase, beneficiaries one way or another in that sense. They're not critical to they're part of the process, but you are the necessary party here.
We are, and we weren't only not served with a notice of appeal, and I will say I think it's actually more important in these heightened proceedings because Mr. Schwartz had mentioned that he emailed the board, but that's actually not true. The first the board received an email was a Monday night after close of business notification of case number by email, which we then were able to drill down through to the proceeding and then find that a notice of appeal had been filed. So these notices, they came so late that frankly, and I apologize, I'm far less prepared than I would be had I known that this was coming. The board would be able to, at the lower court process, have been able to put forward the information relating to the underlying proceeding and the disqualification of these petitions. And it was never given the opportunity to do that because this whole thing has been done at a
And so
very.
you're saying that's your prejudice?
That is, I mean, and it's prejudice to the whole system because there's a lot of, it's not like this is the only case and there are so many of them. And if everybody, if some people have to follow the rules and other people don't, there's a sort of appearance of impartiality. And that's the reason that the election law requires some strict compliance in a lot of places, ways that feel rigid sometimes.
So I just want to follow up on one thing you said. You said that after you got this, whatever you received late Monday night, that you then drilled down and found that the notice of appeal had been filed? As
Well,
to your
had been,
client, or
had
as
been
to someone-
filed on the Supreme Court docket because we weren't served, we weren't physically served,
So you
we weren't
you weren't saying that
emailed.
it was filed as to, that you were served with it, but that you found it was showing up on a docket?
They filed it on the underlying Supreme Court NICEF docket, yeah. So we were able to find it there, and from there infer. And I'll note as a separate problem, the order on its face just says that for reasons stated in oral argument, which created additional difficulties on an after hours filing.
We don't have the transcript.
Exactly, and all of that sort of is due to delays in asserting, quickly, promptly responding, as everyone else did, filing a notice of appeal immediately from an adverse decision, immediately asking for transcripts. All of those things would have allowed this court to reach the merits as our adversary tried to raise before the court immediately. I'm happy to address those if the court would rather, but I think I'm out of time. The district positions. Thank you.
I think that's enough. Okay. Do you want 2 minutes? I'll give you 2 minutes.
Briefly respond. First of all, there were two, as to the last point, there were two orders appealed. One had an opinion, so which is the one with the verification, so everybody knew exactly what the judge said. As to the notice of entry and the order, the notice of entry didn't attach the transcript either, and we had literally one day called the court reporter, still haven't been able to get the transcript. Whether
What about the failure to serve the notice of appeal on the board because they haven't agreed to electronic filing?
Even though I don't want to suggest this, because I think I did 7 petitions in one night, which was quite a night, technically under the CPLR, we could reserve the notice of appeal and go through
But the
processing.
statute specifically excludes the board, right, these types of proceedings from the electronic filing. It's not like a surprise. There's a specific exclusion of election matters. So I assume that you, as all other election lawyers, know that you can't do it that way.
Well, I didn't know the board didn't accept electronic filing because prior to this year, except during the pandemic, everything was not electronic. During the pandemic, we started doing it this year. I called the clerk and said, do we have electronic filing for election cases? And the person who answered the phone said, yes, we do this year. So I was not aware that the board wasn't gonna, and I certainly served them with papers to the front desk where they clocked them in. When we initiated the the case in the beginning, the
Right,
initial
but the
petition.
appeal is what I think
But the,
what is in
but the
front of
appeal,
us. You didn't serve them with the
I
notice.
did
of
not do that.
Okay.
And I was
So-
not aware that they didn't
If,
accept
if
that.
we were to agree with the Board of Elections that service wasn't proper with respect to the notice of appeal, what impact does that have on your request for relief in the petitions? Can we grant it?
The court could issue a ruling that the board was wrong. I don't know that if it's like a jurisdictional question, you couldn't order them to take any action. I believe I could file another notice of appeal and go through this process again. I'm not out of time under the CPLR because the decision that we're appealing from was only issued 9 days ago. And we could go through that process, which is what I tried to do in the lower court in the rush of getting things done. And I thought it would be easier to refile, and then we had service issues because the judge made it incredibly difficult. Mr. Newell says that we didn't file an affidavit of service with literally the people served. I emailed, I mailed, I emailed Mr. Newell, and then put in an affidavit saying what had gone on at midnight, and the hearing was at 10 o'clock in the morning. It wasn't exactly like I had time to find the servers and get them to sign an affidavit and notarize it. We're dealing with the exigencies of a very rapid, and the judge made it even more rapid by basically giving us till midnight to serve and show up tomorrow morning at
It's
10
the
o'clock.
fastest procedure I know of.
I call it speed litigating, and it's replete with all kinds of
But it is the
potholes.
nature of the election law proceedings. There is a very, very,
I
very
did ask, on the docket, there is a letter from me asking the judge for another 24 hours since the statute of limitations didn't expire till 24 hours later, and the court said to me, no, we're only hearing election cases tomorrow. We have a trial on Thursday, whatever it is. And so I had to work within that, serving people who essentially weren't home. And if they weren't home and you have till that night, you post it as best as possible. And we posted it, mailed it, emailed it to them. We had everybody's email addresses. And because they were when they filed their objections, they put in email addresses. I sent it to Mr. Newell, who had appeared for them throughout this period of time, who the judge had let me serve the initial petition on. The initial petition, the judge said that I could serve Mr. Newell on behalf of the defendants. And although he said he was served at 10 p.m., what happened is the judge signed it in the early afternoon. I called Mr. Newell and said, can I just send this to you? I'm in court this afternoon. Can I just send this to you electronically? And he said, no, I insist on you coming to my office, which is his home. So I came. It took till 10 o'clock at night. It wasn't like he didn't have notice. He knew what was going on. And I think under the exigencies
Why
of
don't you
this situation.
finish up?
I didn't hear.
I said if you could just finish up, because,
That's it.
okay, I think we got the points and we read them in the briefs. Thank you, counsel. Thank you
There is
all.
a case that I filed a reply this morning. I have no idea if it was accepted or not. But there's a case, Teneriello versus Board of Elections, where it says where the verification, there's a question about the verification, and Mr. Newell says that I didn't address it when we were in front of the judge. He didn't raise the fact that I had typo where I put petitioners. He didn't raise that. He just said an attorney can't verify. That was his objection, you could see.
Okay.
The second department says in this case, and I can hand it up, it's 10480 second 467, that if it's an attorney involved and they're in front of the court should have a short hearing to determine what was intended by the verification. And
Okay.
that could have been,
Counsel?
I talked about it,
Counsel?
but not under oath.
Thank you.
Thank you.
Thank you very much. Thank you all.